Welcome to Advocating for Dads with Jana Jones.
Hello and welcome back to Advocating for Dads with Jana K. Jones. Jana is a family law attorney based in North Carolina who helps fathers navigate custody disputes with confidence and clarity. I'm Kevin Rosenquist, and today we're talking about something that comes up a lot. Does the parent who files first have any sort of advantage in a custody battle? Jana, welcome back.
Hey there, Kevin. Good to see you again.
Yeah, you too. Why bury the lead? Does filing first in a custody or divorce case give someone an advantage?
Objectively, not really. So the court's got decisions to make when they're dealing with divorce, and who filed first is not going to be top of the list that the court's considering. So let's kind of break them down into the different pockets or matters that a contested divorce case with children is going to kind of encompass. So when it comes to a contested divorce, and specifically equitable distribution and alimony, the party who needs the alimony, say, is generally going to be the one who is filing, right? Because they're asking the court to order something from the other party. Obviously, the party who is not interested or is not asking for alimony doesn't need to rush to the courthouse to deal with that particular matter, and frankly doesn't want to deal with it at all. Okay. When it comes to equitable distribution, that's going to be any asset or liability that was incurred between the date of marriage and the date of separation, regardless of whose name is on, or if it's in one name or the other or both names. As long as it was done during that time period, it's going to be subject to equitable distribution. And so there might be pieces of the marital estate that make you want to get into court sooner rather than later. But generally speaking, the court is not going to make a determination as to who gets what based on who filed first. Now, when it comes to custody and child support, custody, I would say there can be a benefit to filing first with custody, because it's telling the court, hey, there's a dispute and I want to get in front of a court to get it figured out. So I think it can be beneficial to an extent to go ahead and file first if you can. However, the court's polar star when determining custody is always going to be the best interest of the child. So let's say, for instance, you have a parent who has custody of the child, maybe not per a court order, but just by default at this point. And there's another parent who is asking for either joint custody, primary custody, or some type of visitation schedule. And the parent who has the child isn't allowing it to happen. Well, the parent who has the child doesn't necessarily have a need to go to court, right? They already have what they want.
Right.
It's the parent that needs some sort of evaluation to be done so that they can get some custody or visitation rights in place that needs to go to court. And so in that instance, it is not simply that because the parent who's asking for some type of custody rights files first, that means that they're just going to switch the custody around, right? The court's job is to determine best interest. And so they're still going to be considering that. So it can play a role, but I wouldn't say it's a big role, and I wouldn't lose any sleep over it. Most important thing is, if you are not the party that files first, you're not the plaintiff, you're the defendant, that you are filing a timely response. In North Carolina, you get 30 days to file an answer to a complaint for custody or any other type of complaint. You can ask the court for an additional 30 days through a motion in order to enlarge time, so that gives you a total of 60 days to file a response. And keep in mind, when we're talking about 30 days and 60 days, this is from the time that you are properly served with the documentation, with that complaint and summons. That's when that clock starts. So it's going to be crucial. That's more important than who filed first, that whoever filed first, the party who did not file first and is the defendant, files some type of response within the required time period.
Okay, that definitely makes sense. Is there a way to really strategize your response when you're the respondent, when you are served, and is there any particular strategy that works best out of the gate? Is it case by case?
I would say it's case by case, but whenever you're responding to a complaint, the first piece of it is called an answer. And so that is where you're going through each and every paragraph in the complaint and saying admitted or denied, or admitted in part, denied in part, et cetera, and explaining your response to their allegations. And then there's the counterclaim, which is the second part of the response of pleading. And that is where you're telling the court what you're filing for, what you're asking for. So in a case where somebody files, say, a complaint for custody, the other party who's responding is going to answer the complaint for custody, and then they may file their own counterclaim for custody and maybe child support as well.
And you said 30 days is you want to respond within 30 days unless you get an extension. Are there other deadlines or timelines that need to be adhered to?
Not for filing a responsive pleading. It's 30 days that's given statutorily, and then you can ask for an additional 30 days, so a total of 60. And again, the key is from the day you're served. So, if something gets filed, it's not getting served the same day. So somebody might file something on a Monday, but they don't get it until 2 weeks later because the post office was slow, or there have been challenges getting them served. And for various reasons, they don't even know about the filing for a couple of weeks. Well, that 30-day clock starts when they actually get served, not when it's filed. So that's a key piece to make sure that parties keep in mind.
Do you find a lot of people think that there's a big advantage to filing first?
Yeah, I do find that. And I quickly let them know that there may have been a slight advantage, but truly what the court is considering, especially say in a custody case, it's going to be about the best interest of the child or children, not who filed first. It's just not something that the court is going to use as one of the things that they are evaluating when they're making a determination about best interest of the child.
Okay. So it does sound like it might have a small impact here and there, not a huge impact, because again, as we talk about a lot, like you said, best interest of the child. Our show is advocating for dads. Should dads make an effort to file first, in your opinion?
Yeah, I mean, if you're being denied time, if you've got an arrangement or don't have an arrangement at all, that you're not happy with, or that you're struggling with your co-parent about, then absolutely you should be filing, because otherwise you're left where you are, right? You've tried to work it out, you try to talk it out, you try to find a schedule that you can both live with, and you just cannot come to an agreement on it, then really the only option is to go ahead and file for custody. And that's exactly what my clients are doing. They're reclaiming their time, as we say, because you're entitled to time with your child, and your child needs both of you in their lives. And so if the custodial parent is keeping you from the time that you deserve, then you have to fight for what you're wanting.
We've talked about the myth of that courts would favor mom as far as custody disputes, and we've debunked that myth in past episodes. Do you think that there's any sort of lean sometimes in courts? If a mom goes first, it's like, well, obviously it's mom and she went first. Whereas if dad goes first, it doesn't have the same look or impact.
No, I wouldn't say that. Again, we've got good judges in Mecklenburg County, and they really are focused on the best interest of the child or children when they're determining what the custody schedule is going to be and what's going to be the most appropriate schedule. And so they're not looking to see who filed first, and they're not going to give anybody the upper hand, dad or mom, for filing first. They really are tasked with determining what is going to be in that child or children's best interest as it relates to a schedule.
Do fathers make mistakes in this early stage here that you think they need to avoid, that you'd like to kind of bring out in the episode here today?
I'd say the biggest mistake that I see fathers making is waiting too long to get the time they deserve with their child. So when the court is determining best interest, like we've talked about in previous episodes, stability is really, really crucial. And so if you've got a situation where mom, for instance, has had primary custody of the child for all their lives, and the kid is 10 or 11 years old, right? And now you're saying as dad, I want joint custody. Well, the court's going to say, we understand and we love that you are trying to be more involved than you have been all these years, but is this going to be in the child's best interest? What is mom doing wrong, and what are you doing right that is going to outweigh the fact that this is going to create instability, at least for a little while, for this child who is accustomed to being with mom the majority of the time? And so that's usually the biggest mistake that I see fathers making, waiting too long to file. When they have maybe a very young child, an infant or toddler, and they're like, well, I'm not trying to take the child away from mom. I understand the sentiment behind that idea, but the reality is, if you do not stand firm on what you're entitled to with your child as early as you can, the longer it goes, the more difficult it becomes to change that custody schedule, unless mom's just done something that it makes it abundantly clear to the court that it's not going to be in the child's best interest for the child to remain with mom in a primary care situation. But barring that, assuming everything is fine, mom's doing mom's job like she's supposed to, and you simply want more time, and this child has gotten up in age and maybe isn't old enough, as we've talked about in previous episodes, to articulate what they want for the court to hear from that, if that's not going to be appropriate or something that the court's just not going to be interested in, then it's going to be really, really difficult for dad to get that additional time, because he's going to have to demonstrate to the court that it's not that it's unfair that I'm not getting this time, but that it's in the child's best interest that I get this time.
All right. Well, thanks for listening to Advocating for Dads. If you're navigating a custody case and unsure what kind of evidence can help or hurt you, always chat with Jana. You can visit lawofficeofjkj.com to connect with her. Don't forget to subscribe, leave us a review, share the episode with a dad who needs it. We appreciate you being here. Jana, always great having you. Thanks so much for your time.
Thanks, Kevin. Appreciate it.
Thanks for watching. If you like this video, don't forget to hit that like button and subscribe to our channel for more amazing videos like this one.